All right, good afternoon, everyone. I'm Judge Corey Amanda Cotham. We're here for the afternoon session of first appearances. Excuse me. As a reminder to everyone, today is not your trial date, and so I do encourage you to speak to your attorneys before speaking on the record this afternoon, because everything that we say is being recorded and can be used against you at a later date. To begin, I have a few cases that have been requested to be called out of turn from Maine. I believe there are 3. So I'll start with those. All right, the first one on my list is Francis Oakley, who is on page 2 of the felony hearing docket.
Mr. Oakley, come on up, please.
This is a second look.
Judge, he has been in custody for 5 days. His bond is $750.
All right, good afternoon, Mr. Oakley.
Good afternoon, ma'am. How you doing?
I'm well, thank you. All right, so his bond is $750. Mr. Romero, what do you want to tell me?
Judge, unfortunately, nobody can afford to pay his bond. The only person that could is his uncle that's out of town, and Mr. Oakley does not know his phone number. My understanding, he's been here his whole life. He works when he can in the labor pool. He lives in Pompano Beach. Judge, I'm asking for the court to consider releasing him on pretrial release. Now, he did advise me. This year he's been clean. Last time he got in trouble or picked up a new law offense was last year, Judge.
Okay. Did you say that he has a residence?
Correct. It would be in Pompano Beach.
Okay. All right, Mr. Linder, I'll go to you.
State would be opposing pretrial. It would appear that Mr. Oakley has been qualified as a career offender. I'm showing that he has been in repeat offender court previously, showing 3 separate cases in 2012. One for 2 counts of dealing in stolen property, false ownership info, and a pawn item. Another for dealing in stolen property, burglary of a conveyance and theft. And a third case for burglary of a dwelling, grand theft from a residence. In each case, he was sentenced to 54, basically a little over 54 and a half months in state prison. He also had a possession of cocaine in 2012, same sentence. A burglary, conveyance, and grand theft, 2011, same sentence. His most recent prior was if I could just check one thing, Your Honor. Nancy, could you check? I'm showing he was in pretrial last year on a grand theft. Were there any issues? Thank you.
Judge, and speaking of Mr. Oakley, he said most of those serious offenses, which the state was referring to, are a little bit dated, a couple years old. He advised me last time he had contact, which he told me about was the one from last year. From what he says, he was placed on, I believe, pretrial, and he said he had no violation.
I
How
understand.
long was he on
Let
pretrial?
me just confirm it with pretrial.
Well, yeah.
2 months, no issues?
And yes, it is correct. Well, I don't know that I'd agree that they're dated. Mr. Romero's definition and mine of what's dated is a little different. But I would also ask the court to consider a substantial amount of that time he was serving in prison.
And Judge, I believe the petty theft here, and I can be wrong, I haven't had an opportunity to read the PC. I believe it was from Walgreens, and I believe it was hygiene products.
I don't have it in front of me to confirm that. All
I don't
right.
know that I would call Rogaine as a hygiene product.
All right, since I understand he's got the lengthy history, but since he was on pretrial last year, didn't have any issues, I'm willing to give him a chance and put him on pretrial supervision. All right, it'll be standard pretrial. Mr. Oakley, understand though you're going to be released today, you must report to pretrial supervision within 24 hours. If you fail to report to them, as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
I understand completely, Your Honor, and I really appreciate it, and thank you for giving me a chance.
All right, thank you, Mr. Oakley. Good luck. Thank you. All right, next, I have, one moment. Mr. James Jones on page 4 of the misdemeanor docket.
Mr. Jones, come on up. He's approaching, Judge.
Okay.
All the way down.
All right, good afternoon, Mr. Jones.
Sir.
And Mr. Jones is
Good
here.
good afternoon, ma'am.
All right,
How are you?
Mr. Jones is here on a second look. His bond is $25. And
Judge,
I will-
Mr. Jones wanted to know if the state had a plea offer for him today.
Let's see.
The adjudication time served, no return to this particular Publix.
Judge, I explained to Mr. Jones what the state's plea offer is, the fact that he can't return to that place, and I also explained to him as far as what two prior convictions means the third time he gets arrested on a petty theft amount, and understanding all of his rights, he wishes to accept the state's offer.
All right, Mr. Jones, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Jones, do you understand everything we've discussed so far this afternoon?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No, not right now, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. Mr. Jones, what plea do you wish to enter? Guilty or no contest?
No contents.
All right. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication of guilt with time served. And once again, there is a no return order to that Publix location. And you understand that, Mr. Jones?
Yes, ma'am, I do.
All right. Thank you very much. Good luck to you, sir. It was time served. All right. And then I have one more case on the first appearance docket. Mr. Kemp on page 4.
Richard.
There's the returns.
Okay. Yes. Okay. All right. Good morning, or excuse me, good afternoon, Mr. Kemp. You're before the court this afternoon on 5 charges. Count 1, second-degree petty theft. Count 2, DUI, alcohol or drugs. Count 3, resisting an officer obstructing without violence. Count 4, refusing to submit to a DUI test. Count 5 is riding a bike at night with no lights. That is not for magistrate. And Mr. Miller, I will hear your probable cause argument.
Thank you, Judge. On count 1, there's no identification, although circumstantial evidence would tend to find that this is the person who's accused of shoplifting the 2 cases of beer. He was not identified by the clerk. Count 4, refusal to submit to a DUI test. There's no probable cause because he was not driving a motor vehicle. And I understand that the DUI statute is expanded to include bicycles, but the refusal statute is specifically motor vehicles. So there's no PC here.
All right. Mr. Linder, your response?
I don't know that I agree with the argument in count 4, but it's really neither here nor there since there's no bond attached to it. I think based on the circumstantial evidence, I think there's enough for probable cause for count 1.
I do note that there was no ID by the person from the store, but it does indicate in the probable cause affidavit the defendant fit the exact description of the suspect and was also carrying the exact items that were taken from the store without payment. So based on that, as well as the location that this occurred at, I am going to find probable cause for count 1. Even though I do note that there's no bond attached to count 4, I'll find no probable cause for count 4 as a technical issue. All right, and I find probable cause for the remaining counts. All right. And I will hear recommendations from Mr. Romero if he has anything to add.
Judge, Mr. Kemp is requesting that the court would consider releasing him on pretrial release.
Does he have any priors?
Yes, Your Honor. One moment. Showing 2014 resisting a merchant theft, 2010 4 counts of burglary conveyance, 2010 resisting without violence, and I'm also showing, that's interesting. One moment, Judge, I need to confirm this is in.
Okay.
State would be objecting to any type of pretrial. He has a warrant out of the state of Texas from March 12, 2019 for failing to appear in court on a DUI.
All right, based on that information, I'm gonna leave the $500 bond in place. All right, thank you. Good luck, Mr. Kemp. All right, is there anyone else that needs to be called out of turn at Maine? Or any of the jails for that matter?
No, Your Honor, we're good, thank you.
Okay, thank you. Mr. Miller, you have any of the other jails that needs to be called out of turn? Okay, all right, so, let's go to, Tremaine Hill, who was reset from this morning's docket.
He's approaching, Judge.
Thank you. All right, good afternoon, Mr. Hill.
Yes.
All right, Mr. Hill, I understand that you have private counsel, and I know that your attorney spoke with Mr. Linder from the state attorney's office earlier. Mr. Linder,
Thank you, Your Honor. Yes, I spoke with Mr. Kuma, who's representing Mr. Hill.
yes,
She could not be here this afternoon. I did get her a copy of the PC affidavit and the warrant,
yes,
so she could review them. We had an opportunity to speak. Considering that both reports stem from the same incident, and a $35,000 bond had already been attached to the warrant by Judge Usan,
yes,
we've agreed to a $7,000 bond on counts 1 and 2. The total bond would be $50,000, $500, including the capias on
okay,
the traffic matter. No victim contact, no possession of any firearms, weapons, or ammunition. Ms. Chikuma advised me for her client's edification. She's handling the case, she's aware of everything, and she will be reaching out to him to discuss the next steps to take.
okay. All right, so Mr. Hill, since I know we're kind of doing this backwards, but since I have you in front of me, I'm gonna read the charges formally for the record. Counts 1 and 2 are aggravated assault with a deadly weapon without intent to kill. Count 3, carrying a concealed firearm. Count 4 is shooting into a dwelling. Count 5 is a traffic capias. I find probable cause, and based on the agreement that your attorney has reached with the state attorney's office, I'm going to set the bonds on counts 1 and 2 at $7,000 each. I will leave the bonds in place on counts 3, 4, and 5 as they have been set.
All right.
Okay, and Mr. Hill, the last two things that we just need to address are, there's going to be an order of no victim contact. So that means that you're not to be in the same place at the same time as the alleged victim, no phone calls or text messages, no third-party contact or social media contact with that person. Do you understand? Okay.
I understand that, Your Honor.
All right, and then the last thing, Mr. Hill, is there will be an order that you possess no weapons, firearms, or ammunition. That means if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand?
Yes, Your Honor.
Okay, all right, thank you very much, Mr. Hill. Good luck to you.
All right. Go up, bro.
All right, next will
bonded.
Okay. Michelle Davis.
North Broward.
Thank you. I'm sorry, what was that, Deputy?
She's in medical reset?
Okay, I think I reset her from yesterday also, right?
You did.
Yes.
All right. In Miss Davis's case, I'm going to make a probable cause finding and we'll have her reset for bond. Joseph Nickerson.
He's here at Main, Judge.
Thank you. Good afternoon, Mr. Nickerson.
Afternoon.
Mr. Nickerson, you're before the court on 2 charges. Count 1 is operating a vehicle with unsafe or improper equipment. That is not for magistrate. Count 2 is an out-of-state felony hold. That is a hold out of the state of Georgia with a no bond hold. I find probable cause. And Mr. Nickerson, since that's an out-of-state hold, that means that you'll go before the extradition judge probably on Thursday of this week so that you can address how that's going to be handled. Excuse me. Good luck to you, sir. Kendrick Lemon.
Mr. Lemon? Kendrick?
This is Mr. Plant's case, actually.
Oh, North Broward.
Okay. All right. All right. Good afternoon, Mr. Lemon.
Good afternoon.
Mr. Lemon, you're before the court this afternoon on 2 misdemeanor capiases. These are municipal ordinance violations, both of which are for panhandling. I find probable cause, and your attorney, Mr. Plant, is with me in the courtroom. And Mr. Plant, what are we doing with Mr. Lemon's case?
Judge, City of Pompano is, he has a choice. He could, it's RR,
Yeah.
or he could just resolve to withhold court costs. RR is risky, he may not. They're gonna no pros, actually. City of Pompano only, but he just wants to resolve it today, because I had one earlier in the morning, and we resolved him to withhold.
Okay.
So he could resolve it and
Okay.
put this behind him.
Mr. Lemon, do you understand what Mr. Plant's just said?
Yes.
Only for this charge, sorry.
What would you like to do today, sir?
Resolve it now.
All right. And they're both withholding court costs?
Yes, Your Honor.
All right. Okay, Mr. Lemon, you understand the offer on both of the cases is a withhold of adjudication and court costs?
What's that?
I'm sorry?
Just don't, what's that? Just don't return?
There's going to
What
be,
is-
there's not a no return order. It would be a withhold of adjudication plus court costs. Do you understand that?
No, what is that?
Mr. Plant, have you?
You have no conviction. Adjudication is being withheld, so it's not gonna go on your record as a conviction.
All right, not
It's
a
a plea
problem.
of convenience.
All right, not a problem.
All right, Mr. Lemon, you understand that?
Uh-huh.
Okay, do you want to resolve the case and accept that offer today?
Yes.
All right, I'm going to ask you a few questions before we're done. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes. Yes.
All right, thank you. Now you can put your hand
Hand
down.
down.
Mr. Lemon, do you understand everything we've discussed so far this afternoon?
Yes.
Is anyone forcing you to resolve these cases?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, I understand.
Okay, have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I understand.
All right, and Mr. Lemon, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence as to both matters will be a withhold of adjudication plus court costs.
All right.
Good luck to you, sir.
Look, sir.
All right.
Next will be Mark DiNardo.
He's approaching, Judge. He's here at Main. Come on up,
Thank you.
Mr. Bernardo.
All right, good afternoon, Mr. DiNardo.
Good afternoon.
Mr. DiNardo, you're before the court this afternoon on 2 charges. Count 1, burglary with assault or battery. Count 2, resisting an officer or obstructing without violence. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor, excuse me, the state is going to be seeking a finding of proof evident or presumption great, and ask that Mr. DiNardo be held no bond for first appearance purposes only. I spoke with Mr. Acevedo, the victim, this afternoon before court. He is very concerned for his safety, but more importantly for his family's safety. So the court's aware, well, as far as the strength of the evidence, there were multiple witnesses to this incident. The elements would satisfy, the allegations would satisfy the elements that Mr. DiNardo entered the apartment without permission. He unlawfully entered the apartment. He committed a battery against the victim. There were allegations that he went after 2 other people, but the officer did not believe it rise to the level of a battery. It should be noted, and they're referenced in the report, Barbara Guerrero and Felipe Guerrero. Those are Mr. DiNardo's grandparents. I know it says next to Felipe Guerrero, child, but that's not correct. They're his grandparents. They live downstairs in a different apartment. There has been incidents with Mr. DiNardo and his girlfriend and his grandparents, and Mr. Acevedo's grandparents. He's advised me they've been threatened in the past. His child, who's referenced in here, is 4 months old. Sometimes his wife stays home to watch the child during the day. Sometimes his grandmother stays home to watch the child during the day. He's very concerned for their well-being during the day when he cannot be home because he's working. And the reason for this concern is, as you can see, Mr. DiNardo literally lives next door to Mr. Acevedo and his family. And that is the reason for his concern, and that's why he is requesting that the court at this time hold Mr. DiNardo no bond. He is requesting, if the court should deem it appropriate to set a bond for Mr. DiNardo and that no bond is not appropriate, that there be release conditions in place to ensure that he cannot come, that he has to stay away from his family's residence.
Okay. All right. Thank you. We'll go to Mr. Miller next.
Well, Judge, I'm looking at the clerk's computer here, and Mr. DiNardo has a few tickets, driving on a suspended license, possession of weed, nothing violent in his past, and I don't know if that's just in Broward or if that's everywhere. But there's something here that doesn't quite fit. We don't know and I always object for the court finding probable cause based on a document. And that document only contains one side of the story. It only contains what the police want you to read. What the question that kind of jumps off the page at me is why? Why would he go in there? There's said something about the girlfriend going in there and him coming in and afterwards. Was there an intent to commit a battery when he went into the house, or did something happen that caused the alleged battery to occur? To get to proof evident presumption great based solely on this document, without any testing, without any hearing the other side of the story, it just seems such a reach in this situation especially. So, Your Honor, I'm going to ask the court to find that proof is not evident based solely on the contents of this probable cause affidavit, and to grant him a bond.
All right. Well, what I have before me today is the probable cause affidavit. And, you know, Mr. Miller, with respect to your argument, you're probably right. There may be some other outside information, but that's the entire purpose of an Arthur hearing if that becomes necessary. So, for today's purposes, for first appearance, based on the information provided in the probable cause affidavit, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. DiNardo be held no bond on count 1. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge, so that if there is other information that needs to be taken into consideration, that would be the appropriate time to address those matters. All right, and in an abundance of caution, I am going to place an order of no victim contact as well as a no return order, which will apply should Mr. DiNardo become eligible for release. Mr. DiNardo, so that you understand those orders, that means that you are not to go to the residence that is at issue in this case. You are not to have any contact with the alleged victim. That means no being in the same place at the same time, no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that, sir?
I understand.
All right, thank you very much. All right, next will be Eduardo Valanuez.
He's approaching, Judge.
Thank you. Good afternoon, Mr. Valanuez.
Yes, good afternoon.
All right, sir, you're before the court this afternoon on 3 charges. Count 1, possession of cocaine. Count 2, obstruction. Count 3 is a bike regulation violation that is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, I'm going to be requesting the court consider releasing Mr. Villanuez on pretrial release. Right now, he's not working. He lost his job. He was detailing vehicles. He lives in Miami with a friend where he's been renting at. About $250 a month is what he was paying. But unfortunately, since he lost his job, now he's a little bit kind of like he's not caught up on his rental amount. He's been here almost half of his life. He's 38 years old, and he did tell me that he has prior contact with the criminal justice system, but it's been at least a year. So, Judge, on this nonviolent offense, we're asking if the court will consider releasing him on pretrial release.
All right, Mr. Linder.
I'm just trying to figure out, because I don't know how far West Park is from where he says he's residing, but he's arrested at midnight on a bike in West Park allegedly with cocaine in his possession. Doesn't really, I mean, I'm just trying
Sure,
to make
Romero,
sense
where
of
does
it.
he live? Because I have a Miami address.
Ives area, which is basically kind of on the border between Dade and Broward,
Okay.
the northern part of Dade County.
Okay. South County.
It's not bad. That's fine. Let me see.
Judge, according to Google Maps, West Park and the Ives area section of Miami they border each other.
Yeah, Your Honor, I'm fine with pretrial with random testing.
Okay. All right, so Mr. Valanuez, I'm willing to place you on pretrial supervision under the condition that you will be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. Do you understand that? Do you understand, sir?
Yes, sir, I understand.
Okay, all right. Additionally, Mr. Romero has given you some information there that you need to read after we're done here today. Though you're going to be released today, you must report in person to pretrial supervision within 24 hours. If you fail to report to pretrial as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
I understand that. Thank you, appreciate it.
All right, thank you. Good luck. Alexei Mikhailovsky.
Here, here at Main Judge approaching.
How you doing, Your Honor?
I'm well, thank you, Mr. Mikulowski. All right, sir, you're before the court this afternoon on 4 charges. Count 1, possession of a prescription drug without a prescription. Count 2, possession of cocaine. Count 3, possession of morphine. Count 4, possession or use of drug paraphernalia. I find probable cause, and I will hear from the parties.
Judge, we're gonna be requesting pretrial, see if the state has an objection before I proceed.
It's fine.
It'll be with random testing.
Yeah.
That's fine, Judge.
All right, Mr. Mikulowski, I will release you to pretrial supervision on the condition that you be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. Do you understand that?
Yes, ma'am, thank you.
All right, so Mr. Romero's giving you a piece of paper there. Make sure you read it when we're done here today. That gives you information on what you need to do next. You're going to be released today, but you must report to pretrial supervision within 24 hours. If you fail to report to them, as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yep.
All right, thank you. Good luck. Rashawn Thomas.
Good morning, Your Honor.
All right, good afternoon, Mr. Thomas. Mr. Thomas, you're before the court on 4 charges. Count 1, possession of cocaine. Count 2, disobeying a stop or yield sign. That is not for magistrate. Counts 3 and 4 are felony probation violations, which have no bond holds. I find probable cause. And Mr. Thomas, I do see you're going to have a hearing with your division judge tomorrow morning to address the violation of probation. So in light of that, do the parties wish to be heard on count 1?
No, Judge.
Okay, all right, I'll leave that bond in place. Thank you. Good luck, Mr. Thomas. Adrian Finch,
Approaching Judge Main.
thank you. Good afternoon, Mr. Finch.
Good afternoon.
All right, Mr. Finch, you're before the court on 6 charges. Count 1, possession of methamphetamine. Count 2, possession of GHB. Count 3, possession or use of drug paraphernalia. Count 4, driving while license suspended, second offense. 5, failure to display vehicle registration. 6, failure to provide proof of insurance. 5 and 6 are not for magistrate. I find probable cause, and I will hear from the parties.
Judge, nothing to add at this time.
Okay, anything from the state?
No, Judge.
All right, I will leave the standard bonds in place. Thank you. Good luck, Mr. Finch. John Green.
Medical reset, Your Honor, I believe.
All right. We will go to the misdemeanor docket. Where did Mr. Plant go? Well, let's start with the felony docket since I don't know where Mr. Plant just went. All right, first up will be Karen Foley Walton on page 2 of the felony docket.
Hold on, Your Honor.
Thank you. All right, good afternoon, Ms. Foley Walton.
Good afternoon.
You are before the court on a second look hearing, and it looks like this was pending, pretrial pending verification. Okay, so can I get an update from pretrial on what's going on with Ms. Foley Walton? Thank you. Mr. Plant, Ms. Foley Walton has she has an MO case as well, I just realized.
Yes, Judge.
Yes. Okay, so all right, so that pretrial is telling me that Ms. Foley Walton gave a plantation address. That was pending verification, and when they made contact with the residents there, they indicated that Ms. Foley does not reside there.
Well, that's kind of not what we asked. The address Ms. Foley gave was for her sister, and she was going to try to reside with her sister
Which is where?
at the address that they gave. They're saying that Ms. Foley doesn't live there. She doesn't live there. She's going to try to stay there with her sister.
It's pending pretrial's verification, that's where she's going to be staying. She gave the wrong address, is that what you're saying? She gave the wrong address?
Didn't match. The address is Orlando, out of the.
I understand that too.
Yeah, I need to get back to Orlando. I mean, that was my
Judge,
goal.
she's
I
asking the
came
court
here
to put back her bond.
for a job on the Seminole Reservation.
All right, okay,
She has bonds.
The bond's still in place. It's just,
right.
So post the
Just
bond, Ms.
post the
Foley.
bond.
Okay, so the bond will remain in place, as it was set then we won't have to worry about pretrial. Okay?
No argument, Judge.
All right, so that'll apply to both the felony and the misdemeanor.
Thank you, Judge.
Okay. All right, so Ms. Foley Walton, you'll just need to post the bond.
Okay, thank you.
All right, thank you. Okay. Mr. Plant, don't go anywhere. All right, I'm working on the felony docket right now, but don't leave.
Yes.
All right, next will be Christine Walsh on page 2 of the felony docket.
she bonded.
Okay, great. On page 3 of the felony docket, Willie Dudley.
Northborough, Your Honor.
Thank you. Good afternoon, Mr. Dudley. All right, Mr. Dudley, you're here on a second look hearing. Your bond is currently set at $1,000.
Judge, I
Miller?
spoke with Mr. Dudley earlier. He's just waiting for his family to bond him out, so we'd ask the court to take no action.
Okay. All right, so Mr. Dudley, based on that information, I'll leave the bond as it is. All right?
Excuse me, when is it gonna come close to just a regular court account call?
Well, a hearing date hasn't been set yet, but you'll get notification of that in the mail.
Alright,
Okay? All right, thank you, sir. Next will be Jonathan Samuel.
He bonded, Your Honor?
All right. And that brings us back over to the misdemeanor docket. On page 2 of the misdemeanor docket, Terrence Hammond.
Conti?
Thank you. And Mr. Plant, this is yours.
yes, ma'am.
All right, good afternoon, Mr. Hammond. So, Mr. Hammond, you're here for a second look today. Mr. Plant, your attorney's with me in the courtroom. And Mr. Plant, I see Mr. Hammond's bond is currently set at $100. Is that
What's the
correct?
second look?
It means
The
that we
second
are
time look.
taking a look at your bond since you haven't bonded out yet, so we can see what's going on. All right, so Mr. Plant, what do you want to tell me?
Judge, he was in front of you on February 19th and resolved. And he got a time served then.
Yes.
So, he is Judge Pohl. I'm not sure if, and we just had him also for the same trespass, same charge.
Okay, so there's no offer from the city today?
No, it wouldn't be, there's no offer due to, and
Priors.
that was the same trespass that it was around Christmas,
Okay,
so
so,
there's too many cases.
all right, so Mr. Hammond, what Mr. Plant is telling me is that due to recent priors with the same allegations, there's no offer from the city at this time to resolve the case. So you have a $100 bond in place, so you can either post the bond or you'll be going in front of your division judge. And if that's the case, then you'll see your attorneys at that time, all right?
Yes, I don't understand, I don't know the charges that I'm in here for.
They're for trespassing,
And what else?
possession of drug paraphernalia,
And that's it?
as far as I know.
The same exact charges you've had, and so you had Mr. Shade and myself, so we'll see you in front of Judge Pohl,
All right,
Okay,
or you can bond out, but.
all right.
alright.
Thank you, Mr. Hammond. Good luck to you, sir. Okay, next will be James Franklin.
Northborough.
Thank you.
Yes, ma'am.
All right, good afternoon, Mr. Franklin.
Good afternoon, ma'am.
All right, Mr. Franklin has 2 cases on the docket on 2 and 4, and he's here for a second look.
And Judge, after speaking with Mr. Franklin and discussing with Mr. Plant,
Yes.
we're asking the court to transfer these cases to Judge Lerner Wren and to take no further action at this time.
All right. Okay, so I'm going to leave the bond in place in Mr. Franklin's case, and I will sign orders transferring both cases to Judge Lerner Wren's division. All right. Mr. Franklin, good luck to you, sir. You'll be in front of your division judge within a few days.
Okay.
Good luck.
Good luck, sir.
That's it for you, Mr. Plant? All right. Next will be Tiara Holiday.
All right, y'all.
Thank you. All right, good afternoon, Ms. Holiday.
Good afternoon.
Okay, and Ms. Holiday is here on a second look. Her bond is set at $100. Go ahead, Mr. Miller.
Consider resolving this charge. She has I believe it's an out-of-state hold. And even if she were to bond out, she would not be able to be extradited, so we'd ask to resolve this so that she can move on.
Okay, I do see she has an out-of-state hold. Is there an offer from the state on this?
Yes, Your Honor. The state would offer an adjudication time served to resolve it, as long as she understands, because considering her out-of-state holds are for vehicle burglary, 2 counts of theft over $1,000, and 2 counts of fraudulent use of a credit card, and they're all crimes of dishonesty. No one has any idea how her judge in that state is going to respond to a plea to a false ID to law enforcement.
Okay. Ms. Holiday, do you understand that?
Yes.
All right, and what is it you would like to do today on this count?
Solve my case.
You want to resolve it?
Yes.
All right, so the offer is an adjudication of guilt with time served. Do you understand that?
Yes.
Okay. All right, so I'm going to ask you a few questions before we're done. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Ms. Holiday, do you understand everything we've discussed so far this afternoon?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right, and Ms. Holiday, what plea do you wish to enter, guilty or no contest?
No contest.
Okay, I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication of guilt with time served. Good luck to you, ma'am.
Thank you.
All right, next will be Esther Edison.
All right, y'all.
Okay. All right, good afternoon, Miss Edison.
Good afternoon.
Okay, Miss Edison is here on a second look. Her bond is set at $100. Mr. Miller, we'll go to you first.
She has no one to bond her out, and that's it. We have no one to bond her out, nowhere to go when she does bond out.
Your Honor, her case was referred to Judge Lerner Wren by the mental health specialist at North Broward Bureau.
Okay.
It was on an email that was sent out yesterday. She has been before Judge Porth and Judge Lerner Wren in the past.
Okay. So what I will do is this. In Miss Edison's case, I'm going to leave the bond in place, but I will sign an order transferring her to Judge Lerner Wren's division. So she'll, at a minimum, be able to get in front of Judge Lerner Wren within the next few days and be able to address those issues further. All right, so Miss Edison, you'll see your judge within a few days. Okay, good luck. All right, next will be Michael Nichols.
North Broward.
Thank you.
Good, Brian.
Okay, thank you. Good afternoon, Mr. Nichols.
Good afternoon, Your Honor.
Mr. Nichols, you're here for a second look hearing. Your bond is currently set at $2,500. And Mr. Miller, I'll go to you first.
I spoke with Mr. Nichols. He hasn't bonded because no one has the money to bond him out. He and his wife both live on disability. After the food is bought, the bills are paid, there's just no money left over to post the bond. No one is stepping forward to post the bond for him. He does have a place to live when he gets out. He's a veteran of the United States Navy. I would ask the court to reconsider a pretrial release for him.
Mr. Linder, go ahead.
Your Honor, just reviewing the PC, and I think part of the issue why Judge Bristol raised the bond to $2,500 has something to do with where he lives. He's the victim's neighbor, and according to the report, he went there uninvited and unprovoked, committed a battery against this woman. It's really, I mean, that's all I see. Obviously, I wasn't here over the weekend. I don't know that I've heard anything that would justify reducing it from the bond that Judge Bristol deemed appropriate.
Judge, it's likely that this case is going to resolve in Veterans Court. The problem is waiting that month for the case to be filed, he's going to be sitting.
May I speak?
Probably not a good idea, Mr. Nichols.
Okay. But my landlord has given us a notice that we must move, and my wife is disabled with PTSD, and I have end-stage liver disease. And this disease is causing malfunctions with my brain. It's called amnioencephalopathy. So I really can't tell you for sure what transpired that day, but I know that I went to talk to
Okay,
Ms. Donnelly.
Mr. Nichols, hang on one sec. We'll just press the pause button for a minute, okay? Because I understand what you're saying to me, but I don't want you to start going into any details about the facts of the case, okay? So just hang tight for a second.
Okay. Yeah, she cannot make the move without me. That's impossible for her to leave.
Okay, I understand.
We've been married
When is that move supposed to be happening, Mr. Nichols?
by the end of the month.
Okay. And do you know where you're going to be moving to from here?
No, ma'am, we have to start looking, and we've already started packing. It's going to take me at least 3 weeks.
All right, go ahead.
Sorry. I just got off the phone with Dennis Salisbury.
Yes.
He's the assistant state attorney that represents the state at Veterans Court.
Yes.
Frankly, the way he explained it to me is it'd be his preference if Mr. Nichols is a veteran and it looks like he's going to be going to Veterans Court, to have him be placed on a monitor as opposed to any type of bond. That way they can keep track of him. They can make determination if he's drinking, if he's using, as those are commonplace issues.
They want a GPS or a TAD? What are they asking?
What I would ask is, from the way described to me, GPS, but with random testing.
All right.
Judge,
so,
we would just ask it to be an open schedule.
Hold on 1 second, Mr. Nichols. Hang on. Go ahead.
We would just ask it to be an open schedule and no objection to random testing.
That's fine, Judge. Yep.
Okay. So, Mr. Nichols, here's what I'm going to do. All right? We'll try to balance everything out here. Instead of having a monetary bond, I'm going to place you on pretrial supervision under a few conditions.
Yes, ma'am.
Number 1, you will have a GPS monitor, that's an ankle monitor on, okay? But it's gonna be with an open schedule, so you can come and go as you need to with the move, okay? But you're gonna have to wear the monitor. And you're going to be subjected to random drug and alcohol testing. So that means no alcohol, no intoxicants. You understand that?
Yes, ma'am.
Okay, all right, so pre-trial will send someone to fit you for the GPS monitor, and you'll be released after that, okay?
Thank you, ma'am.
All right, and Mr. Nichols, I'm just going to say, I'm sure this was discussed over the weekend at the hearing, but remember, there is a no victim contact order in place. So if this is your neighbor, then you need to understand it is very important. Do not be in the same place at the same time or have any contact with that person. You understand?
Yes, ma'am. I do.
Okay, all right. Thank you. Good luck to you, Mr. Nichols.
Thank you.
All right. Thank you both for that. All right, next will be Timothy Roberson. Okay, let's go to Conti. All right, good afternoon, Mr. Roberson.
Good afternoon.
All right, Mr. Roberson, you are here on a second look hearing. His bond is currently set at $100. And Mr. Miller, I'll hear from you first.
Judge, I did not get a chance to talk with Mr. Roberson. He wasn't there when I was making phone calls.
Okay, you want a couple minutes to talk to him?
Briefly, sure.
All right,
Thanks.
Mr. Roberson, Mr. Miller's gonna call you on the telephone there at the jail so he can speak to you privately for a moment, and then I'll bring you back in, okay?
Okay.
All right, go ahead.
Sure. Adjudication. Judge, this is gonna be his third arrest in 3 months, so if you could just advise him, thank you.
All right, Mr. Roberson is back, and Mr. Miller, you had the chance to speak to him,
I did, Your Honor.
okay?
Mr. Roberson would like to resolve this case if the court is so inclined.
All right, what is the offer from the state?
Adjudication time served, Judge.
All right, so Mr. Roberson, if you want to resolve this case today, the state's offer to you would be an adjudication of guilt with time served. Do you understand that?
Yes.
All right. And Mr. Roberson, I understand you have a few relatively recent arrests. I need you to understand that if you keep picking up new charges, there may not be a plea offer in the future. We may be having a very different conversation about things. Do you understand that?
Yes.
All right. So for today's purposes, the offer is going to be an adjudication time served. Okay?
Yes.
All right. So I'm going to ask you a few questions before we're done. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. And Mr. Roberson, you understand everything that we have discussed here this afternoon?
Yes.
All right. Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No. No, thank you.
Okay. And do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
All right. Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
Okay. And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right. Mr. Roberson, I accept your plea and find that it is freely and voluntarily given. Your sentence in this case will be an adjudication of guilt with time served. All right.
Okay.
Mr. Roberson, do good, okay? Good luck.
All right. Thank you.
Okay, and then I have one more case on our docket that is for Daquan Scarlett. Okay.
I did not speak with him.
Okay, I don't have any information on Mr. Scarlett, so let's see if he's gonna be here, then I'll give you a couple minutes to speak to him. North Broward, do you have Daquan Scarlett? Is anyone at North Broward?
It was reset from yesterday. I don't know. I wasn't here.
I see that, I'm trying. Mr. Linder, on the Daquan Scarlett case, I remember, I can't remember the specific reason. I remember Mr. Goldberg, we had a conversation yesterday about resetting it to today, but I don't remember the
Yeah,
reason that
I'm
we
trying to
had.
remember if it was a medical reset or a refusal, or he just wasn't brought down.
Oh, I think, yeah, it was one of those.
I mean, is there any, there's no one there at North right now?
No, we're trying to call. Are there any deputies at North Broward that can hear me? I know we're trying to put in a phone call to them right now. If someone is there, please come on the screen so I can ask you a question. Okay, hi deputy.
Hi, Anna.
Deputy, I had another case for Daquan Scarlett. He was reset from yesterday to today. I don't remember if yesterday he was a medical reset or if he was a refusal. But I remember we did have him reset to today. Do you have any information on him?
I could call a unit for him to check.
Okay, it's my last case, so if you don't mind, what I'll do is, I'll just go off the record for a few minutes. If you could just call back to the courtroom and let me know what's going on with him.
I will, thank you.
Thank you. All right, we'll go off the record for a few minutes while we find out, and then we'll come back on. All right, so Mr. Miller, you heard back from North Broward on Mr. Scarlett's case?
I did, and according to Deputy Mullins here, sorry,
Scarlett? Scarlett?
Mr. Scarlett has decided not to accept the court's invitation. And so I'm not going to ask the court to reset this.
Okay, all right, so since this is a second look, I will go ahead and deny it, and that way Mr. Scarlett can either bond or go to division. All right, Deputy, thank you very much, I appreciate the help.
You're welcome, Your Honor. Have a nice afternoon.
Same to you. All right, so that brings us to the end of our docket for today. I'll see everyone back here tomorrow. Thank you.